Welcome back, history lovers. Tonight we are going to spend a few slow, quiet hours in the strangest courtroom ever built. The medieval one. Not the grand halls you've seen in paintings with their carved oak and their solemn men in fur, but the odd little chambers where someone once stood up, cleared his throat, and argued in perfect Latin on behalf of a rat. There are no ads tonight. No interruptions, no sudden music, nothing designed to jolt you awake. Just a voice, a long stretch of history, and a series of laws so bizarre that when historians first found them in the archives, they assumed the ink had been smudged. It hadn't. Every one of these rules is real in the sense that matters most. Someone, somewhere, sat down with a quill and made it official, because something happened that they never wanted to happen again. And that's the thread we'll follow all night. Because here is the thing most people misunderstand about medieval law. We tend to imagine that these strange statutes came from strange minds, that people in the Middle Ages simply woke up superstitious and legislated accordingly. But that isn't how law works. Law is reactive. Law is scar tissue. Every truly ridiculous rule in history exists because someone did something so specific, so unrepeatable, so profoundly stupid, that the only reasonable response was to write it down and forbid it forever. Somewhere behind every absurd medieval decree is one incident. One trial. One afternoon that went catastrophically wrong in front of witnesses. So settle in. Get comfortable. Let the room go dark. You don't need to follow every name or every date. Let them drift past you like villagers seen from a slow river. If you fall asleep in the middle of a trial, that's fine. The verdict will still be there tomorrow. Let's begin with the rats. In the early years of the 16th century, in the French diocese of Autun, a green, unhurried place of vineyards and low stone walls, the barley began to disappear. Not all at once. That's what made it maddening. A farmer would walk out at dawn and find a patch of his field hollowed out from beneath, the stalk standing upright but empty, the grain gone. Then another patch. Then a granary floor covered in fine dust and small deliberate holes. Rats, thousands of them, moving through the countryside like weather. Now a modern village would call an exterminator. A medieval village had two options, and both of them were spiritual. You could pray, or you could sue. Autun, being French and therefore constitutionally incapable of leaving a grievance uninstitutionalized, chose to sue. This sounds insane, and it was, but there was a logic under it that's worth understanding, because it explains almost everything strange that follows tonight. In the medieval worldview, creation was a single unified household with God as its master. Every creature in it had a place, a duty, and, crucially, a relationship to divine order. A rat eating a man's grain was not merely a pest. It was a subject behaving improperly, and improper subjects could be summoned, warned, tried, and, if they refused to reform, excommunicated, cast out, cursed by the church, and driven beyond the boundary of the parish. So the ecclesiastical court of Autun opened a case against the rats of the diocese, and because this was a formal proceeding, and because formal proceedings require both sides to be represented, the court appointed a defence attorney. His name was Bartholomew Chassin, and he was young, ambitious, and almost entirely unknown. He had been handed what everyone in the building assumed was a joke, a career-ending assignment, the legal equivalent of being asked to guard an empty room. Chassin did not treat it as a joke. Chassin treated it as the greatest opportunity of his life, and in doing so, he became one of the most quietly influential lawyers in European history. His first move was procedural, and it was beautiful. The court had summoned the rats. The rats had not appeared. The prosecution moved for a default judgment. The defendants had ignored a lawful order, so the case was over before it began. Chassin stood and objected. His clients, he said, had not been properly served. Think about that for a moment. He didn't argue that rats couldn't be tried, because that argument would have lost, and it would have lost immediately. He accepted the premise entirely. Yes, my clients are rats. Yes, they are subject to this court. and then he attacked the process. The summons, he pointed out, had been read aloud in a single parish, but the defendants were dispersed across the entire diocese. A man summoned to court in a town he has never heard of cannot be held in contempt for failing to attend. The notice was defective. The service was invalid. The court, to its eternal credit, agreed. A new summons was ordered, this time proclaimed from the pulpit of every parish church in the diocese, so that no rat could claim ignorance of the proceedings. The day arrived. The court convened. The rats once again did not attend. And here Chassin rose for the argument that made his name. His clients, he explained, were not defying the court. They were afraid. The roads between their homes and this courtroom were patrolled by cats, hostile parties, well known to bear malice toward the defendants, and known further to act on that malice with lethal force. Under established legal principle, a defendant who has a reasonable fear of bodily harm on the journey to court cannot be compelled to make that journey. Therefore, before his clients could be expected to appear, the plaintiffs must guarantee their safe passage. The plaintiffs must, in short, restrain their cats. The villagers of Autun, needless to say, refused to post bond for the good behaviour of every cat in the diocese. And so the case stalled. It stalled beautifully, permanently, in that particular way that legal cases stall, when a clever man has found a door in the wall that nobody knew was there. Chassin went on to become one of the most respected jurists in France, a president of the Parliament of Provence, an author whose treatises were read for centuries, and the arguments he made on behalf of vermin about adequate notice, about the defendant's right to safe passage, about the difference between refusing a court and being unable to reach one, were not laughed out of the profession. They were written down. They were cited. They hardened into the procedural rules that governed animal trials across Europe for the next 200 years, and some of them have distant, respectable descendants still working quietly in courtrooms today. That is the pattern. One absurd case. One lawyer who took it seriously. And a rule that outlives everyone who thought it was funny, because after Autun, the courts had a template. A summons had to be published widely. A defendant had to be given a reasonable opportunity to comply. A defence had to be genuinely mounted, not merely performed. And the men who wrote these procedures did so with completely straight faces, because to them the alternative, arbitrary punishment, without process, was far more frightening than the sight of a lawyer arguing about cats. Now let me take you somewhere colder, and a little sadder, because not every animal trial ended in a clever stalemate. The place is Savigny, in Burgundy. The year is 1457. And the crime is not a nibbled granary. A sow had killed a child. The details are recorded with the flat precision that medieval clerks used for everything. And I won't linger on them, because they're grim and because you're trying to sleep. What matters is what happened afterward, because the sow had not been alone. She had a litter. 6 piglets, young, found near the scene, spattered and squealing and utterly bewildered. The court charged all 7. And this is where the story turns into something genuinely remarkable, because the trial that followed was not a farce. The judges of Savigny approached it with the full apparatus of criminal law, and in doing so they were forced to confront a question that legal philosophers were still wrestling with 4 centuries later. The sow was tried and convicted. That much was expected. She was an adult animal, she had acted, and under the doctrine of the time, she bore responsibility for the act. She was sentenced to death. But the piglets were the problem. The prosecution argued that they had been present, that they had participated, or at minimum benefited, and that under the principle of shared guilt, they were accomplices. It was not an unreasonable argument by the standards of the day. Medieval law was full of collective liability, whole villages fined for the crime of one man, whole families dispossessed for a single act of treason. The defence argued something new. The piglets, it was said, were too young. They had no capacity to understand what was happening. They had followed their mother because that is what young creatures do, and to follow is not to choose. And where there is no capacity to choose, there can be no guilt, only misfortune. The court deliberated, and then the court did something that still makes historians sit up in their chairs. It acquitted the piglets. They were released into the custody of a local man on the condition that he take responsibility for their future conduct, which is the medieval equivalent of a suspended sentence with supervision. The record notes, with a kind of bureaucratic tenderness, that their youth was the deciding factor. Sit with that. In a courtroom in Burgundy in 1457, a panel of judges established, in writing, that infancy is a defence against criminal liability, that guilt requires understanding, and that a creature which cannot comprehend a rule cannot be condemned for breaking it. They established it about pigs. But they established it, and the ruling did not stay in the pen. It was cited. It circulated. It became one of the small, strange precedents that jurists reached for when they argued, in the centuries that followed, about children in the dock, about whether a boy of 7 could hang, about at what age a person becomes fully answerable for what they do. Every legal system on earth now draws a line somewhere between the child and the adult. And one of the first places that line was ever drawn clearly, deliberately, and in the official record was a courtroom in Savigny, over 6 piglets who did not know what a crime was. That's the thing about the Middle Ages that nobody tells you. It was not an age of stupidity. It was an age of relentless, obsessive, almost unbearable seriousness applied to premises we no longer accept. Give a medieval jurist a false starting point, and he will build you a cathedral of flawless reasoning on top of it, and some of the stones in that cathedral will turn out to be load-bearing for the next 500 years. We have a long night ahead, and it gets stranger from here. There's a belle that was arrested, flogged, and exiled to Siberia. There's a nobleman who cost an entire kingdom the right to wear a certain colour. There's a corpse put on trial, and a rooster, and a duel between a man and a dog that changed the rules of evidence in France. But for now, just rest. The rats got away with it. The piglets went home. If you drifted off during the piglets, don't worry. Nothing important happened. A lawyer argued about cats, 6 young animals were spared, and the sun went down over Burgundy the way it always does. You've missed nothing but the setting of a very old sun. We're going to move east now, and then west again, and we're going to look at 2 of the strangest defendants ever to stand before a court. One of them could not speak. The other could not move. Neither of them had done anything wrong in any sense we would recognise. Both of them were punished anyway, and both punishments left a mark on the law that lasted long after everyone involved had turned to dust. Let's start with the belle. The town was Uglitch, on the great slow curve of the Volga, about 150 miles north of Moscow. It was a modest place, timber houses, a Kremlin of white stone, a cathedral, and above the cathedral, a bell. Not an especially famous bell. Not the largest in Russia, not the finest cast. It hung in its tower and did what bells do. It marked the hours, it called people to prayer, it rang for weddings and it tolled for the dead, and in an emergency it rang the alarm, which in Russian was called the nabat, the sound that meant drop everything and run to the square. On the 15th of May, in the year 1591, a boy died in the courtyard of that Kremlin. He was 9 years old. His name was Dmitri, and he was the youngest son of a dead Tsar, which in the politics of that moment made him either an irrelevance or the most dangerous child alive, depending on who you asked and how quietly they answered. What happened in the courtyard has been argued about for 400 years, and will be argued about for 400 more. The official commission that came from Moscow concluded that the boy had suffered a seizure while playing with a knife and had fallen on it. His mother's family said, loudly and immediately, that he had been murdered on the orders of Boris Godunov, the man who effectively ruled Russia and who would, 7 years later, be crowned Tsar himself. Historians remain divided. I'm not going to settle it tonight, and honestly, neither will anyone else. What is not in dispute is what happened in the minutes afterward. Somebody ran to the bell tower, somebody seized the rope, and the alarm bell of Uglitch began to ring, not the measured toll of a funeral, but the frantic, irregular hammering that meant catastrophe, that meant fire or flood or invasion, that meant every soul in the town should come running with whatever they were holding. And they came, hundreds of them, pouring into the courtyard, and what they found was a dead child and a story already forming in the air above him. Within the hour, there was a mob. By the end of the afternoon, there were bodies, the men accused of the killing, and several others who happened to be standing near them, torn apart in the square by neighbours who a day earlier had sold them bread. Moscow's response was thorough, and it was cold. The commission arrived. The verdict came down, accident followed by riot. And then came the punishments, which were distributed with a very particular sense of who was responsible for what. Around 200 people were executed. Many more had their tongues cut out. Hundreds of families, some accounts say most of the town, were loaded onto carts and deported to Siberia, to a settlement at Pelim, at the far edge of everything, where the forest goes on until it stops being forest and starts being tundra. And then the authorities turned with complete seriousness to the bell. Because the bell had summoned the mob. Not the man who pulled the rope, he was punished separately, in the ordinary way. The bell itself. It had raised the alarm, it had gathered the crowd, it had, in the language of the sentence, borne false witness, calling the people to an emergency that was not an emergency, and everything that followed flowed from that sound. So the bell was taken down from its tower and brought into the public square, and there it was tried and condemned like a man. It was flogged. 12 strokes, publicly administered, on a mass of bronze that felt nothing and would remember nothing, in front of a town that had just watched its own people die. Its tongue was cut out, the clapper, which in Russian is called the yazik, the same word used for the tongue in a human mouth. That detail is not a coincidence, and the men who ordered it knew exactly what they were doing. The bell had spoken. So the bell was silenced in precisely the manner used on the townspeople who had spoken too. One of its ears was cut off, the mounting loop by which it hung sheared away so that it could never be properly rehung. And then it was sentenced to exile. It was dragged out of Uglich and hauled overland, over 1,000 miles, to Tobolsk in Siberia, where the local governor is said to have refused at first to accept it, on the reasonable grounds that he had never before been asked to imprison a musical instrument. It was eventually installed in a tower there and labelled, in the records, as the first inanimate exile. Now you might reasonably ask what possible purpose this served, and the answer tells you almost everything about how power worked in that world. It served 3 purposes, and all of them were real. The first was theatrical. In a society where most people could not read, law was performed rather than published. A statute nailed to a door reaches the literate few. A bronze bell being whipped in a public square reaches everyone, forever, and is retold by grandmothers for a century. The punishment of the bell was the announcement of the verdict, written in a language that every single person in Russia could understand. The second was theological, and it was the same instinct we saw in Autumn. If the world is a single ordered household under God, then a thing which does harm has stepped out of its place, and things which step out of their place must be corrected. The bell had been given a purpose, to call the faithful, to warn of true danger, and it had been used against that purpose. It was, in the reasoning of the time, a corrupted instrument. You do not simply melt down a corrupted instrument. You correct it, publicly, so that the correction is seen. And the third purpose was the practical one, the one that actually mattered to the men in Moscow, and the one that turned this bizarre spectacle into law. Because what the events at Uglich revealed was a vulnerability. Anyone at all, could climb a tower and pull a rope, and within 90 seconds have several hundred armed and frightened people assembled in one place, with no information and no leader and no idea who had summoned them or why. The alarm bell was the most powerful communications device in the Empire, and it was hanging in every town, unguarded, available to any fool or any conspirator who could climb stairs. The punishment of the bell was the declaration that this had ended, and in the years that followed, across Russia and in a scattered way across Europe, the rules tightened. The ringing of the alarm bell became a regulated act. In town after town, the keys to the bell tower were taken from the general keeping of the church and given into the custody of named officials. Ordinances specified who might sound the alarm, on whose authority, and in what circumstances. False alarm, the sounding of the nabat without cause, became a distinct and serious offence, punished not as mischief but as something closer to sedition, because the men writing the laws understood exactly what a false alarm could produce. They had seen it produce 200 corpses and an empty town. That is a real principle, and it is still with you. Every jurisdiction you have ever lived in has a law against raising a false alarm, against pulling the handle when there is no fire, against reporting a bomb that does not exist, against the deliberate manufacture of panic. We tend to think of these as modern rules, born with the fire brigade and the telephone. They are older than that. They come from towers and ropes and bronze, and one of the clearest ancestors of them all was hammered out in a square in Uglich, while a mutilated bell lay on the ground. The bell, incidentally, came home. 300 years later, in 1892, after a long and gloriously petty legal dispute between the town of Uglich and the city of Tobolsk over ownership, a dispute in which both sides submitted documents, cited precedent, and behaved as though they were arguing over a person, the exile was pardoned and returned. It hangs in Uglich to this day, tongueless, one ear missing, and visitors come to look at it, which is more attention than most defendants ever get. Now let me take you west and a little further back to a story that is almost certainly not true, and which changed the law anyway. This one is French, and it begins in a forest outside Montargis, sometime around the middle of the 14th century. A courtier named Aubry de Montdidier rode into that forest and did not ride out. He was, according to the story, murdered, struck down and buried under leaves by a man he had quarrelled with, another courtier named Richard Macaire. There were no witnesses. There was no body at first. There was nothing at all except the fact that a man had gone into the trees and failed to come out the other side. Except there was one witness. Aubry had a dog. A greyhound, in most tellings, though the breed shifts depending on who is telling it. The dog came out of the forest alone, half-starved, and went to the house of a friend of its master and would not settle. It ate, and then it left. It returned, it left again, and eventually somebody followed it, and the dog led them into the trees and stood over a disturbed patch of earth and would not move. And they dug, and they found Aubry. That should have been the end of it. It was not, because a dog standing over a grave tells you where a man is, not who put him there. But then the dog began to behave strangely. Wherever it went, it was calm, except in the presence of one man. When Richard Macaire came near, the animal changed entirely. It bristled, it lunged, it had to be dragged back. It did this once, and people thought it odd. It did it 12 times, in 12 places, in front of 12 different sets of eyes, and people stopped thinking it was odd and started thinking it was testimony. Word reached the king. And the king, Charles V, in most versions of the tale, did something that seems to us completely mad, and which was, by the standards of his own courtroom, entirely correct. He ordered a trial by combat, between the accused man and the dog. And to understand why that decision was not lunacy, and what it eventually destroyed, we need to talk about what trial by combat actually was, and what it was for, and why the collapse of it took the whole medieval theory of evidence down with it. But that's where we'll pick it up. Rest for a moment. The bell is quiet now. The dog is waiting in the dark at the edge of the forest, and it has nowhere to be. The forest outside Montargis, then, a dead courtier under a shallow layer of leaves, a greyhound that will not stop snarling at one particular man, and a king who has just ordered the two of them to fight. to understand why that order made sense. And it did make sense. In its own airtight and terrible way, you have to stop thinking of a medieval trial as a search for the truth. It wasn't. Not primarily. A modern trial is an investigation. We gather facts, we weigh them, we reason our way toward the most probable account of what happened. A medieval trial, in its older form, was something else entirely. It was a request for a ruling, and the entity being asked to rule was not the judge, it was God. This is the single idea you need to hold on to tonight, because almost everything strange that follows grows out of it. The court's job was not to decide who was guilty. The court's job was to construct a situation in which the guilt would be revealed, to build a proper, formal, ritually correct channel through which heaven could deliver a verdict that human beings were too limited to reach on their own. The judge was not the decider. The judge was the plumber. Think about how sensible that is, given what they had. No forensics, no photographs, no fingerprints, no timestamps, no records. Most crimes had no witnesses, and the witnesses that existed were neighbours who might be lying, or frightened, or paid. When a man says he did not do it, and another man says he did, and there is nothing else, nothing at all, what do? You could guess. You could let the wealthier or louder man win. Or you could hand the question to the only authority that was believed to be both omniscient and incorruptible, and then abide by the answer. So they built channels, and the channels were the ordeals. There was the ordeal of hot iron, in which the accused carried a glowing bar a fixed number of paces, and the hand was bound and sealed, and after 3 days it was unwrapped and examined. If it was healing cleanly, God had spoken for the accused. If it had festered, God had spoken against. There was the ordeal of hot water, in which a stone or ring was dropped into a boiling cauldron, and the accused reached in to retrieve it, and the same waiting and the same unwrapping followed. There was the ordeal of cold water, which is the one that people half remember and always get backwards. The accused was bound and lowered into a body of water that had been blessed. If he sank, he was innocent, the pure water had accepted him. If he floated, the water had rejected him, and he was guilty. It was not a trick. It was not designed so that you drowned either way. There were ropes, and there were men holding them, and the sinking was meant to be brief. The logic was consistent blessed water does not embrace a liar. And there was combat. Trial by combat was the aristocratic ordeal, the one for men who carried swords, and it operated on the same principle as all the others. 2 men make contradictory claims. Only one can be true. Put them in a field, let them fight under formal rules, and God will grant victory to the one whose cause is just. The strong man does not win because he is strong. The strong man wins because God permits him to. If the weaker man triumphs, that is not an upset, that is the entire point of the exercise, and it is precisely the outcome everybody has come to see. Which brings us back to the dog, because once you accept the framework, the king's decision stops being madness and becomes something closer to elegant. Here is a case with no witness, except that it may have exactly one witness, and that witness cannot be cross-examined, cannot swear an oath, cannot describe a face. The dog cannot testify. But the dog can fight, and if God is willing to reveal the truth through the outcome of a combat, then God does not particularly care about the species of the instrument he uses to reveal it. So they cleared a space on the Le de la Cite in Paris, according to the story. Macaire was given a weapon, in most versions a heavy staff or club, chosen because a sword would have made the thing an obvious slaughter. The dog was given nothing, because the dog was already a dog. And to make the contest at least theoretically fair, they gave the animal a barrel, placed on its side, into which it could retreat and from which it could dart out again. You can imagine the crowd. Half of Paris, one assumes, and every one of them convinced they were watching an experiment being run on the universe itself. The dog won. In every telling, the dog wins. It circled, it stayed low, it used the barrel, it wore the man down, and eventually it got past the staff and had him by the throat. and Macaire pinned on his back on the ground with an animal's jaws around his neck, and with the King of France sitting 20 feet away, did the only thing left to do. He confessed. That is the story of the Dog of Montargis, and I want to be honest with you about it, because I think honesty makes it better rather than worse. It is almost certainly not true. The earliest surviving accounts appear well over a century after the events they describe. The names drift, the king drifts, the century drifts. Serious historians treat it as folklore with a thin crust of plausibility. And yet, a tapestry depicting the combat is said to have hung at the Château of Montargis for generations. Travellers went to look at it. Writers described it. In the early 19th century, the tale became a hit melodrama that played across Europe, and audiences wept, and a real dog took the leading role and became famous. Napoleon is supposed to have loathed the play. There is a statue in Montargis now. So which is it? Legend or lore? Both, and that's the lesson worth taking to bed with you. A story does not have to have happened to have consequences. This one was repeated for 400 years in courtrooms and taverns and law schools, and it was repeated as an argument that trial by combat produced justice, that the system worked, that even a dumb beast could be God's mouthpiece if the procedure was clean. It was the showpiece. It was the story you told when someone doubted the ordeal, which means that when the ordeals collapsed, this story is one of the things that had to be explained away. And the collapse, when it came, did not come from septics. It did not come from lawyers or kings or reformers. It came from the church, and it came suddenly, and it broke the entire evidentiary system of Europe in a single afternoon. The year is 1215. In November of that year in Rome, Pope Innocent III convened the greatest ecclesiastical gathering in centuries, the Fourth Lateran Council. Somewhere between 400 and 500 bishops, hundreds more abbots and priors, envoys from every Christian monarch in Europe. It ran for weeks, and it produced 70 canons, and those canons reached into every corner of Christian life. It fixed the requirement of annual confession. It addressed heresy and crusade and the conduct of the clergy. And buried among them was Canon 18. Canon 18 said, in essence, that no cleric might pronounce or execute a sentence of blood, and that no priest was to bless or take any part in an ordeal by hot iron or hot water. That's it. It doesn't ban the ordeal. It doesn't declare it superstitious. It simply forbids priests from participating. But that was enough, because the priest was the whole machine. Without the priest, the iron is just hot iron. Without the blessing, the water in the cauldron is only water. The ordeal was not a physical test. Everyone knew that a hand plunged into boiling water burns. The ordeal was a sacrament with a burn attached. Remove the sacrament, and what you are left with is nothing but the torture of a person who may be innocent, in front of a crowd, for no informational gain whatsoever. The bishops at Rome pulled the priest out of the room, and within a generation across most of Europe, the ordeal was simply gone. Not debated to death, not gradually reformed. Gone, in some places within a decade, leaving behind a smoking hole where the entire theory of proof used to be. Now imagine you are a judge in England or France or Germany in the year 1220. Yesterday you had a method. A man denies the accusation, you send him to the water, God answers, you record the answer. Today you have a courtroom, a defendant, an accusation, no witnesses, and no channel to heaven. What on earth do you do now? Europe answered that question in two different ways, and the split has never closed. You are still living inside it. In England, they reached for something that had been sitting in the corner for a while doing minor administrative work: the jury. Groups of local men had long been summoned to answer questions about land, boundaries, taxes, local reputation. They knew things. They were, in the phrase of the time, the country. So the English took this administrative body and handed it the thing the ordeal used to do: you 12 will decide whether this man did it. It was awkward at first. defendants had to be persuaded, sometimes brutally, to consent to be tried by a jury at all, because they understood perfectly well that they were being asked to swap the judgment of God for the opinion of their neighbours, and their neighbours were not necessarily impressed with them. On the continent, they reached instead for the Roman law being rediscovered in the universities and built a system of proof, a formal calculus of evidence. 2 eyewitnesses of good standing equalled full proof. 1 eyewitness was half proof. Circumstantial indications were fractions to be added up. It was rigorous and it was rational, and it had one catastrophic flaw. In a serious case with no 2 witnesses, the only remaining route to full proof was the confession of the accused. And when the law makes a confession the necessary key to the door, someone will always find a way to obtain the key. That is the road that leads, straight and well paved, to the torture chamber, not as a failure of the system, but as a feature of it. So, a council in Rome removes a priest's blessing from a cauldron, and 800 years later, you have a jury box in one half of the world and an investigating magistrate in the other. That is what I mean when I say these stories are load-bearing. And the dog, in the end, became a curiosity, a story told fondly about a system nobody used anymore, the way we tell stories about horse-drawn fire engines. Next, we're going deeper into the dark, because I promised you a corpse in a courtroom, and that promise is going to be kept. There is a trial coming in which the defendant had been dead for 9 months, was dressed in his former robes, propped in a chair, and assigned a teenage deacon to speak on his behalf. It produced one of the strangest laws in the history of the church, and it happened because one man could not let a grudge die, not even after the man he hated had. Sleep if you can. The forest is quiet now. Rome, then, and I should warn you gently, this next part is the darkest of the night. Nobody is torn apart, nothing is graphic, but there is a strangeness here that sits differently than pigs and bells. It's the strangeness of a room where everyone knows what is happening is obscene, and everyone participates anyway, because the alternative is worse for them personally. The year is 897, and to understand what happens in January of that year, you need to understand that Rome, at that moment, was not the Rome you're picturing. The great basilicas were there, yes, and the Lateran, and the bones of the apostles. But the city around them was a ruin with people living in it, perhaps 20 or 30,000 souls camping in the shell of something that had once held 1 million. Aqueducts broken, forums used as pasture, marble being burned for lime because it was easier than quarrying. And the papacy, in this period, was not a spiritual monarchy commanding Europe. It was a prize. It was the most valuable piece of property in central Italy. And it was fought over by a handful of aristocratic families with private armies who installed their candidates and removed their rivals with a speed that is genuinely difficult to keep track of. In the space of about 10 years around this period, Rome went through something close to 10 popes. Some reigned for years. One reigned for about 2 weeks. Into this, a man named Formosus had risen. He had been a bishop, a papal legate, a missionary to Bulgaria, a diplomat of real skill and real ambition. He had also, at various points, been excommunicated, restored, exiled and returned, because in the politics of 9th century Rome, a career was less a ladder than a series of survived reversals. In 891, he became pope, and during his 5 years on the throne, he made a decision that would kill him twice. The Holy Roman Empire, the imperial crown of the West, was contested between 2 men. One was Lambert of Spoleto, whose family dominated central Italy and whose mother, Agiltrude, was one of the most formidable political operators of her age. The other was Arnulf, king of the East Franks, a rival from beyond the Alps. Formosus had crowned Lambert, and then, later, he had invited Arnulf into Italy and crowned Arnulf instead. Whatever the strategic reasoning, and there was reasoning, involving armies and threats, and the perpetual problem of being a pope surrounded by a family that could reach your bedroom in an afternoon, the effect was simple. He had humiliated the House of Spoleto in the most public manner available in Christendom. And then, In April of 896, before any reckoning could arrive, he died. Old age, most likely. He was in his 80s. He was buried in St. Peter's with full honours. His successor lasted a fortnight. And then the chair went to a man named Stephen VI, who owed his position to the Spoleto faction, and who appears, from everything that follows, to have been carrying a grudge that had metastasized into something the sources struggle to describe. In January of 897, Stephen ordered the tomb of Formosus opened. The body was 9 months dead. It was taken out and carried into the Lateran Basilica. It was dressed in the papal vestments, the pallium, the robes, all of it, arranged on a corpse by men who must have wished very much to be somewhere else. It was placed on a throne. And then the court was convened. This is the trial that history remembers as the Cadaver Synod, and the detail that unsettles people most is not the corpse. It's the procedure. Because they ran it properly, bishops attended. Charges were read into the record. And because canon law required that a defendant be represented, a deacon, a young man, in most accounts barely more than a boy, was appointed to stand beside the throne and answer on behalf of the dead pope. Picture that young deacon for a moment. He is standing next to a corpse in full regalia. The living pope is shouting questions at it, and when the questions stop, everyone turns to look at him, and he is expected to speak. The charges were technical, which is somehow worse. Formosus was accused of perjury, of having violated the oaths sworn during his earlier exile. He was accused of coveting the papacy. And most substantially, he was accused of having transferred from one bishopric to another, of having been Bishop of Porto and then taking the See of Rome, in violation of ancient canons that forbade a bishop from abandoning his diocese for a more attractive one. That last charge is the interesting one, and I'll come back to it, because it is the hinge on which the whole grotesque business turns from spectacle into law. The verdict was guilty on every count. And the sentence was not merely condemnation. It was erasure. The judgment declared that Formosus had never lawfully been pope at all. The vestments were stripped from the body. 3 fingers of the right hand, the fingers used to give the papal blessing, were cut away. Every ordination he had performed, every priest he had made, every bishop he had consecrated, was declared void. The body was reburied in a common grave, and then, according to the chronicles, dug up again and thrown into the Tiber. Now consider what that verdict actually did, once the shouting stopped and men went home and thought about it. Formosus had been pope for 5 years. In 5 years a pope ordains a great many people. Every one of those men woke up the following morning to discover that he was, retroactively, not a priest, which meant that every mass he had celebrated had not been a mass. Every absolution he had granted had absolved nobody. Every marriage he had blessed, every dying person he had anointed, undone retroactively by a ruling delivered to a chair. And those men had ordained others. The nullity spread outward like a crack in glass. Nobody in Italy could be certain that the priest they had confessed to was a priest. Nobody could be certain their child's baptism had taken. This is not a theological abstraction. To people who genuinely believed that the fate of their soul turned on these sacraments, it was a catastrophe on the scale of a plague. And it was self-inflicted, by a court, in an afternoon. The reaction, when it came, was fast. Within months Stephen VI had been overthrown, seized, imprisoned and strangled in his cell. Rome, it turned out, had a limit, and the limit was somewhere just past the throwing of a pope into a river. But the damage was done, and undoing it took years and multiple councils. Successive popes reversed the verdict, then reversed the reversal, then reversed it again as factions swung back and forth. Formosus's body was recovered from the Tiber, fishermen found it, or a monk did depending on the account, and reburied in St. Peter's with honour. The ordinations were declared valid after all. Then invalid. Then valid, finally and permanently, by a synod that had had enough. and out of that exhausting mess came the rules. The first was procedural, and it is beautifully blunt. A synod held in 898 formally prohibited the trial of a dead person. You may not put a corpse in the dock. It seems like something that should never have needed writing down, and that is exactly the point. It needed writing down because it had happened, and because a law is only ever written after somebody has demonstrated the need for it. The second was deeper, and it is the one that outlived everything else. The chaos of the annulled ordinations forced the Church to confront a question it had been circling for centuries. Does a sacrament depend on the worthiness of the man who performs it? The answer that hardened out of this period, drawing on older arguments from Augustine. But given terrible practical urgency by the sight of half of Italy, wondering if it had ever been baptized, was no. A validly ordained priest confers a valid sacrament regardless of his personal sin, and regardless of what is later decided about the man who ordained him. The grace does not flow through the man, it flows through the office. The priest is a pipe, and the state of the pipe's soul does not contaminate the water. That principle is why the Church could survive corrupt clergy without collapsing. It is why a scandal about a bishop does not retroactively unmarry every couple he blessed. It is one of the load-bearing doctrines of Western Christianity, and one of the things that drove it into final. Settled form was a dead man on a throne, and a terrified deacon being asked to answer for him. The third consequence is smaller, but it tells you a great deal about how institutions actually learn. The charge that stuck to Formosus most firmly was the translation charge, moving from one see to another. And the ambiguity in that rule was what allowed a hostile pope to declare a predecessor's entire reign illegitimate. So the rules on episcopal translation were clarified, tightened, and eventually placed firmly under papal authority alone. The loophole that had been used as a weapon was welded shut. There is one more thing about this story that I think about often, and then we'll move on. Everyone in that basilica knew. The bishops who sat there, the notaries who wrote it down, the deacon who spoke. None of them believed they were watching justice. There is no version of the 9th century in which reasonable men thought a corpse could meaningfully be interrogated. They attended because the alternative was to be noticed not attending, in a city where being noticed by the wrong faction was frequently fatal. That is the real lesson of the Cadaver Synod, and it isn't a medieval lesson. Institutions do not usually collapse because the people inside them are stupid. They collapse because the people inside them can each see, individually, that the safest personal choice is to go along with something obviously wrong, and enough of them make that calculation simultaneously. The forms are observed, the charges are read, the record is kept in good Latin, and at the centre of the perfectly maintained procedure there is a dead man in a chair, and nobody says anything. The correction, when it came from outside the room. It always does. Let's leave Rome. The next stories are lighter, I promise, though not by much. There's a law about what colour you may wear, and it exists because of a shipwreck and a shade of purple. There's a rule about the height of your shoes. There's a statute that made it illegal to be too good at something. And there is a bear. Rest now. The Tiber is dark and moving, and it carries everything eventually. Something lighter now, or at least something where nobody ends up in a river. The next few laws all share a common ancestor, and it isn't crime. It's anxiety. Specifically, the anxiety of people at the top of a very rigid social order who wake up one morning and realise they can no longer tell, at a glance, who is beneath them. That sounds trivial. It was not trivial. In a world without identity documents, without photographs, without any reliable way to verify a stranger's claims, appearance was information. What you wore was not decoration. It was a statement of legal status, readable across a market square in half a second, and everybody was fluent in it. A merchant knew instantly whether the man approaching him could be addressed familiarly or had to be bowed to. A magistrate knew whether the accused could be flogged or had a right to be tried by his peers. The clothing was the paperwork, and then, over the course of the 13th and 14th centuries, the paperwork started to lie. The cause was money, specifically the enormous quantities of it that began moving through the cloth towns of Flanders and Italy, through the wool trade of England, through the banking houses of Florence and Lucca. For the first time in centuries there existed a large class of people who were rich without being noble. And what such people do, universally, in every society that has ever existed, is buy the things that rich people have. So a wool merchant's wife appeared at mass in silk, and the wife of a knight, sitting 3 pews forward, looked back, and something in the order of the universe made a quiet cracking sound. The response was the sumptuary law, legislation that dictated what each rank of person was permitted to wear, eat, and spend. Every kingdom in Europe produced them, in waves, over 400 years. And each wave arrived after a specific incident that somebody could not stop talking about. Let's take the most famous colour first, because the colour is where it starts. Purple. Not the purple of your printer, but the true dye, Tyrian purple, made on the coast of the eastern Mediterranean from a secretion harvested from a species of sea snail. The process was foul beyond description. The snails were crushed and left to rot in vats in the sun for days, and the stench of the dyeworks was so notorious that ancient cities zoned them to the downwind edge of town. It took thousands of animals to produce enough dye for a single garment's trim. The finished cloth cost, by weight, more than gold. Rome had regulated it savagely. Under some emperors, the wearing of full imperial purple by a private citizen was not a fashion violation, but treason, the assumption being that a man who dresses as an emperor intends to become one. And that association survived Rome's fall and passed intact into Byzantium, where the emperor's children were literally born in a chamber lined with purple stone, and were called for the rest of their lives the purple-born. Then, in 1453, Constantinople fell to the Ottomans, and the dyeworks went with it. The supply chain that had run continuously for 2,000 years simply stopped. Within a generation, the true purple was effectively unobtainable in the West at any price. And here's what happened next, which I find genuinely funny. The prestige did not die with the dye. It migrated. Scarlet, a brilliant red made from kermes, the dried bodies of insects harvested from oak trees in the Mediterranean, took over as the colour of unimaginable expense, and the sumptuary laws followed it across, sometimes clumsily, with statutes still forbidding purple to commoners long after no commoner could have obtained it if he'd sold his house, while the actual arms race had moved on to red. That is the recurring comedy of these laws. They are always regulating last decade's status symbol. By the time a parliament has argued its way to a statute, the wealthy have moved to something new that the statute does not mention, and the statute stands there guarding an empty doorway. Which brings me to the shoes. I mentioned them earlier, and now we can do them properly, because the story of the poulain is the purest example in all of history of a law created by pure aesthetic escalation. The poulain was a shoe with a long pointed toe. It arrived in Western Europe in the 14th century, and at first the point was modest, an inch or two, elegant, a little dashing. Then it got longer. Then longer, and because the length signalled that you were a man who did not work with his hands, who did not walk far, who did not need to move quickly for any reason, the length became a competition, and the competition had no natural ceiling. By the middle of the 15th century, court records and chronicles describe points extending a foot or more beyond the foot. They had to be stuffed with moss or whalebone to keep their shape. And because a man cannot climb stairs in them, the fashionable solution was to attach a fine chain from the tip of the shoe to a band below the knee, hooking the point up out of the way. Now imagine the practical consequences, and this is where the laws come from. You cannot kneel in them. This is not a small problem in a society where kneeling in church is not optional. Chroniclers complained openly that nobles at Mass were unable to get down properly and were half standing, half crouching through the elevation of the host, which read to observers as either physical comedy or open blasphemy depending on how charitable they felt. You cannot fight in them or run, and there is a persistent and probably true story attached to the Battle of Nicopolis in 1396. where French knights fighting in the Balkans found themselves needing to retreat on foot and had to stop and hack the points off their own footwear with their daggers before they could move. And you cannot walk through a crowded street without becoming a hazard. Court records include complaints of injuries from trodden and tripped over points. So the laws came. England legislated the maximum length repeatedly under Edward IV, capping points at 2 inches for common men, with longer permitted according to rank. Because the point of the law was never safety, it was hierarchy. If everyone had simply been banned, the nobility would have refused. Instead, the length itself was rationed by status, which meant the shoe was converted from a fashion into a license. France legislated it, cities legislated it, and the church weighed in with genuine venom, with preachers describing the shoes as devil's claws and clergy in some dioceses instructed not to give communion to men wearing them. None of it worked, of course. What ended the poulain was not a statute. It was that the fashion changed quite suddenly around the end of the 15th century to an extremely broad, square-toed shoe, and within 20 years men were being mocked for the opposite excess, and cities were passing laws limiting how wide a shoe could be. The regulators, once again, arrived to find the room empty. But now let me give you the strangest category of all, and this one is not comic at all when you look at it closely. The laws that made it illegal to be too good at your job. We think of skill as an unqualified good. Medieval Europe did not. Medieval Europe understood with great clarity that exceptional individual productivity is a threat to a system built on stable collective survival. Consider the guilds. A guild existed to ensure that every master in a trade could feed his family. Not that the best master could become rich, that every master could survive. And so the statutes of guild after guild across Europe restricted, in astonishing detail, the ways a man might get ahead of his neighbours. You could not work after dark. This was framed as a quality rule, that candlelight produces inferior work, and there was truth in that. But the real function was obvious to everyone. If one man may work at night, all men must work at night. And then every family in the street is ruined by exhaustion, and nobody is better off. You could not employ more than a fixed number of apprentices. You could not own more than a fixed number of looms. You could not advertise, call out to customers in the street, or say anything about the inferiority of a rival's goods. In some towns you could not display your wares in a manner designed to draw the eye away from the stall beside you. And critically, you could not undercut. Prices were set. A man who sold cheaper was not celebrated as competitive, he was fined, because he was breaking the thing that kept everyone alive. There is a particular version of this that I find almost moving. In several textile towns, when a new mechanical device appeared that let one worker do the work of several, a gig mill, an improved loom, a fulling apparatus, the town would ban it outright. We remember this as backwardness, as Luddism avant la lettre. But read the ordinances and the reasoning is explicit and unsentimental. This device will make 4 families destitute so that one may prosper, and we have no mechanism whatsoever to feed the 4. No poor relief worth the name, no other industry to absorb them. No possibility of moving elsewhere, because elsewhere has its own guilds and will not admit them. They were not confused about what the machine did. They understood exactly what it did. They had simply decided that the ruin of 4 households was too high a price for the enrichment of one, and they had the legal power to enforce that judgment, which is more than most communities have ever had before or since. Whether they were right is a question I'll leave with you, in the dark, where it belongs. And now, briefly, the bear. Because I promised, and because it's a good place to stop. The setting is a town in the Holy Roman Empire, and the animal in question was a bear kept for baiting, which was a common and appalling entertainment of the period. The bear escaped. Bears do. And in the course of its afternoon of freedom, it caused the sort of damage a large frightened animal causes in a market. Overturned stalls, ruined goods, a number of injuries, and one very significant loss when it got into a warehouse. The bear was killed. That was never in question. What went to court afterward was the argument about money, because the bear's owner claimed he could not be held liable for damage he had not caused and could not have foreseen, and the merchants claimed that a man who keeps a bear has accepted responsibility for everything a bear might do. The court found for the merchants, and the principle it articulated was this: certain animals are, by their nature, dangerous, and a man who chooses to keep such an animal is answerable for the harm it does whether or not he was careless. It does not matter that the cage was strong. It does not matter that he had kept it safely for years. He kept a bear. The bear is the risk, and the risk is his. That is strict liability for dangerous animals, and it is in the statute books of essentially every country on earth today. If your neighbour keeps a tiger and the tiger gets out, no court anywhere will be interested in how good the fence was. A bear in a market square, a merchant's ruined stock, and a rule that still stands. Rest now. Next we go north, to a trial by combat between a widow and a champion, and to the last legal duel ever fought in France, which ended so badly in front of so many people that a king banned the practice on the spot. North then into Normandy, and into the last great legal duel fought in France, a case so famous in its own time that the king rearranged his schedule to watch it, and so uncomfortable in its aftermath that the institution behind it never really recovered. I'll tell you at the start that this story involves an accusation of sexual assault, and I'll tell you also that I'm not going to dwell on it. Not because it doesn't matter, it is the entire centre of the case, but because what happened to the woman at the heart of it has been used as entertainment for 600 years, and I'd rather spend our time on what she actually did, which was extraordinary, and on what the law did afterward, which is the reason we're here. The year is 1386, and two men who had once been friends are no longer speaking. The first is Jean de Carouge, a knight of Normandy. Middle-aged, competent, brave enough, he had fought in Scotland and in France, and had the scars to show for it. He was also, by every surviving account, difficult, litigious, the sort of man who experiences a setback and immediately begins drafting a complaint. He had lost land in a dispute. He had lost a captaincy he expected to inherit. He had, by his own reckoning, been passed over repeatedly, and he had a theory about why. The second man is Jacques Legris, a squire rather than a knight, but wealthier than Carouge, better liked, and crucially, a favourite of the man they both served, Count Pierre of Alenon. Legris was charming, cultured, and shrewd about court politics, in exactly the way Carouge was not. Every piece of land and every office Carouge felt he had lost seemed, from where Carouge stood, to have ended up in Legris' hands. They had been close once. Legris had stood godfather to Carouge's first son. Then the boy died, and the first wife died, and the friendship curdled into something else. In January of 1386, Carouge was away in Paris on business. His mother had gone out for the day, taking the servants with her, and his second wife, Marguerite, was left alone in the house at Capomesnil. When Carouge returned, she told him that Jacques Legris had come to the house that day, and that he had assaulted her. Now I want you to understand precisely how dangerous what she did next was. There was no realistic legal route here. The evidence problem was total: one accuser, one denial, no witnesses. Legris produced an alibi and produced men to support it. He was the Count's favourite. The Count would hear the case. The Count made his contempt for the accusation clear almost immediately and ruled that the whole thing was a fantasy, and suggested that Marguerite had dreamed it. And beyond the evidence problem was the personal one. A woman who made this accusation and failed lost everything: her reputation, her marriage, and quite possibly her life, since a false accusation of a capital crime carried the penalty of the crime falsely alleged. She would be burned. Everyone in the room knew that. She knew it. She made the accusation anyway, and she never once wavered from it, under any pressure, in any forum, over the course of a year. Carrez, and here his difficult, litigious, grievance-collecting nature became, for once, exactly the right instrument, refused to accept the Count's ruling. He took the case over the Count's head, directly to the Parliament of Paris, and he petitioned for the one remedy that could not be blocked by influence. He demanded trial by combat. The Parliament debated it for months. Judicial combat had already been narrowed severely, it required, among other conditions. That the crime be capital, that it be certain the crime had occurred, and that ordinary proof be genuinely unavailable. Lawyers argued each element. The proceedings ran to enormous length. And in the end, the Parliament authorised the duel and set the date, and the young king, Charles VI, then 18 years old, delayed a military campaign so that he could be present. On the 29th of December 1386, in the courtyard of a monastery in Paris, an enormous crowd assembled. Thousands of people. The king in a gallery, with his uncles, with the whole apparatus of the court. And Marguerite de Carouge was brought out and seated where everyone could see her, dressed in black, on a scaffold beside a pyre. Because that was the procedure. In a duel of this kind, the accuser's wife stood as guarantor of the accusation. If her husband lost, the verdict of God was that she had lied. She would be taken from her seat and burned that same day, in front of the same crowd, while the body of her husband was dragged away and hanged. She sat there through all of it. Through the oaths, through the formalities, through however long the fighting lasted. Accounts vary, but nobody suggests it was quick. Both men were unhorsed. It went to the ground. Carouge was wounded in the thigh, badly enough that observers thought it was finished. And then he got a grip on Legris's armour, and got him onto his back, and could not get through the plate, and demanded a confession instead. Legris refused. His last recorded words were a denial. Carouge killed him. The crowd, we are told, erupted. Marguerite was brought down from the scaffold. Her husband was raised up, made much of, given money and a pension. The verdict of heaven had been delivered, and everybody went home. Except that they went home uneasy, and the unease is the part that mattered. Because a certain number of people in that courtyard had watched a woman sit for hours beside the fire that would kill her, dependent for her life on her husband's ability to win a wrestling match, and had noticed that this arrangement had nothing whatever to do with whether she was telling the truth. If Carouge had slipped, if the thigh wound had come an inch deeper, the same crowd would have watched her burn, and would have gone home equally satisfied that God had spoken. The chronicler Jean Froissart, who was not a radical, recorded the outcome and then added, in a tone that is difficult to mistake, that it was a great pity that such a matter had to be settled in such a way, and there is a coda that made it worse. Years later, a condemned criminal is said to have confessed to the assault while awaiting execution for other crimes. Whether that confession was genuine, or coerced, or invented by chroniclers who disliked Carouge, historians cannot settle. But the story circulated. And once it circulated, the duel of 1386 stopped being a triumphant demonstration that the system worked, and became, instead, the case that people cited when they wanted to argue that it didn't. The Parliament of Paris never authorised another judicial duel, not by statute, nothing so clean. They simply stopped granting them. Petitions came in and were refused, and refused and refused, on ever more technical grounds, until the remedy quietly ceased to exist. But it took one more disaster to kill the duel entirely in France, and that one came 160 years later. And it was not about justice at all. It was about a rumour. The year is 1547. Henry II has just come to the throne, and two courtiers, Guy Chabot de Yarnac and Francois de Vivonne, Seigneur de la Chataigneraie, have fallen out over a piece of gossip about Yarnac's private life, specifically about where his money came from and who he had got it from. It was salacious, it was insulting, and it had been repeated in the king's hearing. La Chataigneraie was one of the great swordsmen of the court. Powerful, celebrated, the king's friend, undefeated. Yarnac was not remotely his equal, and everybody knew it, and that was rather the point. The duel was granted, the king personally authorising it, and the court assembled at Saint-Germain-en-Laye in July with the confident expectation of watching an execution dressed up as a legal proceeding. Yarnak, who was neither stupid nor suicidal, had spent the intervening months training with an Italian fencing master, and that master had taught him something specific. Early in the fight, Yarnak made 2 rapid low cuts at his opponent's back leg, behind the knee, severing the tendons. Lahdeniere went down and could not get up. The whole thing had taken moments. And then Jarnac, standing over the greatest swordsman in France, stopped. He asked Lahdeniere to yield. He asked twice. He turned to the king and offered to give the man his life. Lahdeniere, humiliated beyond bearing, refused to answer, and the king, stunned, watching his favourite bleeding on the ground, said nothing at all for a very long time. The wounded man was carried off. He tore off his own bandages that night, rather than live with it, and he died. The French language kept a souvenir. A coup de Jarnac still means an unexpected and devastating blow that comes from nowhere, originally with a strong flavour of dishonour. Though history has softened it, since Jarnac did nothing against the rules and behaved with more grace afterward than anyone else present. But the important consequence was Henry II's. He had authorised the combat. He had watched God, in theory, deliver a verdict, and the verdict had been that the gossip was true and his own friend was a liar, which was not the answer he had ordered. He had also watched a man he loved die pointlessly over a rumour. He swore an oath, on the spot, never to permit a judicial duel again as long as he lived. And he kept it. That was the end of Authorised trial by combat in France. Everywhere else it died the same way, not by abolition, but by disuse and embarrassment. In England it remained technically legal for centuries after everyone had forgotten it. And in 1818 a man named Abraham Thornton, accused of murder and prosecuted through an old private appeal, was advised by a clever lawyer to demand trial by combat. The court, to its horror, discovered that he was entitled to it. The accuser declined to fight. Thornton walked free, and Parliament abolished the whole business the following year, with visible haste. That is how a great many laws die. Not in argument. In a courtroom, when a lawyer reads the statute carefully and points out what it still says, and everybody looks at everybody else. Rest now. Next, the trial of a rooster for laying an egg, and the very strange law that came out of it. A law that, believe it or not, was about the rules of evidence. It's late now, and this next one is a good story for the late hour, because it starts as farce and ends somewhere I don't think you'll expect. The city is Basel, on the Rhine, and the year is 1474. Basel at that moment is a prosperous, self-satisfied place, a bridge town where the river turns, with a cathedral, a young university, a printing trade that would soon make it one of the intellectual centres of Europe. Educated people, lawyers, merchants who had seen the world. And one morning, a man came into the city and reported that his rooster had laid an egg. Now, before we laugh, and we will laugh, briefly, let me explain why nobody in Basel laughed. Because the explanation is the whole point. There was a creature in the medieval bestiary called the basilisk, or in some accounts the cockatrice, and unlike the unicorn or the phoenix, which lived comfortably in the realm of allegory, the basilisk had a reproductive method, and that method was written down in serious reference works that serious people consulted. A basilisk, it was said, hatched from an egg laid by a rooster. Not a hen, a rooster. That egg, incubated by a toad or a serpent, produced a thing whose gaze or breath was lethal, a walking plague that could poison a well, kill a field, empty a street. So when a man in Basel reports a rooster laying an egg, he is not reporting a curiosity. He is reporting the first stage of a public health emergency, in the same register that a modern citizen might use to report a suspicious package. And the authorities responded the way authorities respond to an alarming report from a credible source. They took possession of the object, they secured the animal, and they opened a proceeding. The rooster was arrested, it was held, it was charged, and a public defender was appointed, because by now you know that a defence was required and that the requirement was taken seriously. And the trial that followed, once you strip away the absurd premise, was a genuine and rather sophisticated argument about evidence and intent. The defence case was this. The prosecution has established that an egg was found near this bird. It has not established that this bird produced it. Roosters do not lay eggs. The entire alarm depends on an occurrence that is, by the defence's own admission, contrary to nature. And if the event was contrary to nature, then either it did not happen, in which case there is no case, or it happened by some agency outside the bird, in which case the bird is a victim rather than a perpetrator. Further, and most importantly, an animal has no will. It cannot form an intention. Whatever occurred, it did not choose to occur, and without choice, there is no crime. That last argument should sound familiar. It is the piglets of Savigny again, 17 years later, in a different country, in a different language, being made by a different lawyer who had almost certainly never heard of the case. Which tells you something interesting, that this principle was not a fluke of one Burgundian courtroom, but something that European law kept independently rediscovering, over and over, whenever it was pushed hard enough against a defendant that plainly could not understand what it had done. The prosecution's answer was equally coherent within its own frame. It did not dispute that a rooster lacks will. It argued that this was precisely the danger. An animal without will can be used. It is an instrument, and an instrument in the wrong hands becomes an extension of the hand that holds it. The unnatural event is itself the evidence of the hand. The bird is not being punished for its choices. It is being destroyed because it has become a vessel, and vessels of that kind cannot be permitted to remain in a walled city of 10,000 people. The court found for the prosecution. The rooster was condemned and burned, along with the egg. And I want to sit with that verdict for a moment, because the instinct is to file it under superstition and move on, and I think that's the wrong file. What the Court of Basel actually did was resolve a conflict between two things it valued. It valued the principle of individual culpability. It had just heard that principle argued at length and did not reject it. And it valued the safety of the city, in a century that had been taught by the Black Death exactly what happens when a contagion is not contained early. Faced with a plausible report of an existential threat, and a defendant who could not be harmed in any morally weighty sense, a bird which was going to be eaten eventually anyway, the court took the precaution. Given their beliefs about the world, the calculation was not irrational. It was, in fact, exactly the calculation modern authorities make when they destroy a herd on suspicion, or close a building on an unconfirmed report. Low cost, catastrophic tail risk. Act now and apologise later. Their model of the world was wrong. Their reasoning inside the wrong model was sound. That distinction is the entire subject of tonight's video, and Basel is the cleanest example of it we have. Now, the law that came out of it. Because the trial had a consequence, and the consequence was not what you'd expect from a city that had just burned a chicken. In the years that followed, Basel and a number of neighbouring jurisdictions moved to restrict who could bring this kind of accusation and on what basis. The rooster case had been enormously popular. It had drawn crowds. It had made the city briefly famous. And the immediate result was that people began finding basilisk eggs everywhere and reporting the neighbours whose birds had laid them, and those neighbours were frequently people with whom they had disputes about fences. That is the mechanism that turns a superstition into a weapon. Once a category of accusation exists and is known to be taken seriously, it becomes available to anyone with a grudge, and the accusation costs the accuser nothing while costing the accused everything. So the requirement was added: such claims required clerical inspection and verification before a proceeding could open. A priest or an appointed official had to examine the object and attest to it. You could not simply walk into the town hall and denounce your neighbour's poultry. That is a filter. It is a gatekeeping rule inserted between a private allegation and the machinery of the state, designed specifically to stop a court's docket from being used as a tool of private malice. and it is one of the oldest recognisable ancestors of the idea that a serious charge requires some independent threshold, a grand jury, a magistrate's finding of probable cause, a prosecutor's decision to charge, before the full weight of the law is allowed to fall on a person. The same instinct, incidentally, appears all over Europe in this period wherever an accusation category became popular and abusable. Statutes appear requiring corroboration. Statutes appear penalising the false accuser with the punishment the accused would have faced, which is a blunt instrument, but a real one. In the German lands, the great criminal code issued under Charles V in the 1530s, the Carolina spent considerable effort on exactly this problem, specifying what counted as sufficient indication to proceed, precisely because unregulated denunciation had proven so catastrophic. The eggs themselves, by the way, are entirely real and entirely explicable. Occasionally a hen produces what poultry keepers still call a wind egg, small, yolkless, sometimes malformed. And occasionally a hen with a damaged or aging ovary will develop male characteristics, the comb enlarges, the plumage changes, the bird begins to crow. It is a documented phenomenon. So a village could quite genuinely watch a bird that crowed like a rooster and looked like a rooster produce something egg-shaped, and every observation reported to that court in Basel could have been completely honest. They saw a real thing. They had a wrong theory. The theory did the rest. Let me give you one more from the same family before we stop, because it is even sadder and even more instructive. In several parts of Europe there arose a legal problem concerning what to do about swarms of insects, locusts, weevils, beetles that destroyed crops. And the ecclesiastical courts developed a procedure for it that was, in its way, deeply humane, and which almost nobody remembers. The proceeding was not really a prosecution. It was a negotiation. The court would summon the insects. Counsel would be appointed. And the defence would advance an argument that I find genuinely beautiful, that the defendants were creatures of God, made on the same days as everything else, and possessed of the same right to eat that God had granted to all living things when he told them to be fruitful and multiply. They were not criminals. They were tenants exercising a right conferred by the landlord. The prosecution would respond that man had been given dominion and that the crops were his, and the resolution, in case after case, was a settlement. The court would rule that the insects must depart from the cultivated fields, and in exchange, the community must set aside a specified piece of land, uncultivated, where the creatures might live and feed unmolested. The parcel would be described in the judgment, its boundaries would be recorded. Sometimes the community would be required to demonstrate good faith first, to pay its tithes, which it had been neglecting, on the theory that the infestation was a consequence of that neglect. The obligation ran both ways. The pests had to leave, but the humans had to fix themselves too. Think about what that ruling actually is, stripped of its theology. A community facing an ecological problem convenes a formal proceeding, hears the interests of the non-human party articulated by an appointed advocate, and resolves it by setting aside protected habitat in exchange for the withdrawal of the species from productive land. That is a wildlife easement. That is a set aside. That is, in embryo, the basic move of every conservation compromise ever negotiated. You may have this land, we will keep that land, and both parties have standing. They arrived at it by a route we would find unrecognisable, through a doctrine we no longer hold, in courts we would not accept. And they arrived at a solution that a modern environmental lawyer would look at, sigh, and admit was more or less correct. The rooster burned, the locusts got a field, and in both cases the court believed it was doing exactly the same thing, putting a disordered piece of creation back where it belonged. Rest now. Next we go to the strangest legal institution of all, the one where a court could hear a case brought by a dead person, and where an entire kingdom once ran on the sworn testimony of people who had been asleep. Deep in the night now, and this part belongs to the dead. Not corpses in courtrooms this time, but something quieter, We're going to look at the medieval world's answer to a question that no legal system has ever fully solved. What do you do about the testimony of someone who cannot be questioned? Let's begin with the memory of water. In the north of England, in the 12th century, there was a dispute between two abbeys over a stretch of riverbank. Nothing unusual in that. Monasteries litigated constantly, and the great carcheries of the period are full of these quarrels. What made this one difficult was that the boundary in question had been set by a grant made over 150 years earlier, and the document describing it had been lost in a fire and the river had moved. So the court did what such courts did. It summoned the oldest men in the district. This is a procedure that ran across all of Europe for centuries and which we have almost completely forgotten, and it deserves better. Before written record was universal, the memory of a community was a legal instrument. It had a name, in England, the inquest of the countryside, the sworn recollection of men of good standing. And these men were not witnesses in our sense. They had not seen the events. What they carried was something else, the thing their grandfathers had told them, which their grandfathers had been told in turn. Testimony, in other words, that reached backward through the dead. And the courts developed elaborate rules for handling it, because they understood perfectly well how fragile it was. A recollection was stronger if the person recalling it had been told the fact in a formal setting, at a boundary walking, at a manor court, at a funeral. It was weaker if it was casual gossip. It was strongest of all if the person could name the man who had told him, and that man's reputation for honesty could itself be attested. You are watching, in these rules, the birth of the entire law of hearsay, the vast, tangled body of doctrine that governs when a court may hear about what someone said outside the room. Every modern legal system has it. Every law student despises learning it. And it began here, with old men on riverbanks trying to remember where a hedge used to be. And there was a specific institution built to make those memories stick, which is one of my favourite things in all of medieval practice. It was called beating the bounds, and in England it survived into living memory. Once a year, usually in the week before Ascension, the whole parish would walk its boundary. The priest would lead, the church wardens would follow, and crucially, the children would come. At each significant marker, a stone, an oak, the corner of a wall, the bend of a stream, the procession would stop, and the boy chosen for it would be taken to the marker and given something memorable. In gentler versions, he was turned upside down and bumped against the stone. In older and rougher versions, he was beaten with a willow switch, or had his head dunked in the stream, or was rolled in the ditch. This was not cruelty for its own sake, though I'm sure it didn't feel like a distinction at the time. It was data storage. That boy would be alive in 60 years. He would be the old man the court summoned. And when a lawyer asked him where the boundary ran, he would not have to think about it, because the answer was written into his body. This is the stone where they held me upside down, and this is the ditch, and I remember the ditch very well indeed. The parish was writing its property records into children, because children last longer than parchment and cannot be burned. Now, the dead. There was a category of proceeding in medieval England called the appeal of felony, and it was not an appeal in our sense. It was a private prosecution, brought not by the crown but by the victim, or, if the victim was dead, by the victim's next of kin. A widow could bring an appeal for the death of her husband. It was one of the very few circumstances in which a woman's private legal action in a capital case was fully recognised, and this matters because it meant that the dead man had, in effect, a continuing legal presence. The wrong done to him did not evaporate with him. It passed, like property, to his widow, who could pursue it in his name. When she stood up in court, she was not asserting her own injury, she was carrying his. The formalities were strict and unforgiving. The appeal had to be brought within a fixed time. It had to be pleaded in precisely correct words. A single error and the whole thing failed, and this severity was deliberate, because everyone understood the risk of allowing a private citizen to drag another private citizen toward the gallows out of malice. The technicality was the safeguard. And there was one more procedure in this family, and it is the strangest of all. It was called the hue and cry, and it made every person in a community into an arm of the law. If a crime was witnessed, the witness was required to raise the alarm, to shout, and to keep shouting, and everyone who heard it was legally obliged to drop what they were doing and join the pursuit. Not permitted. Obliged, a man who heard the hue and did not come out of his house could be fined. You can see why it existed. There was no police force. There would not be one for 600 years. The only enforcement mechanism available was everybody, all at once, immediately. And you can also see, immediately, the problem, the same problem we met in that Russian bell tower. A mechanism that instantly assembles an armed and angry crowd on the word of one person is a mechanism that can be pointed at anyone. So the law grew a callus around it. Raising a false hue became an offence in its own right. Communities were fined collectively if the pursuit was not properly conducted, and fined again if a man was killed in the course of it without justification. The obligation to chase came bundled with liability for how you chased. That bundle is one of the oldest recognisable ideas in policing, that the power to pursue and the accountability for the pursuit must travel together, and that neither may be handed out alone. Now let me give you the dream trials, because I promised you sleeping witnesses and I meant it. There is a recurring problem in medieval records that modern lawyers would call the problem of the unverifiable claim, and it appeared most often in cases involving the discovery of relics, hidden treasure, or the location of a body. Again and again, somebody would come forward and say, "I was told in a dream." A saint appeared to me and told me where his bones lay. A voice told me where the murdered man was buried. A vision showed me the spring that would heal. And the courts, ecclesiastical courts mostly, could not simply dismiss these, because the whole framework of the culture held that God did in fact communicate this way, and the histories were full of authenticated examples. Nor could they accept them, because the incentive to invent a convenient dream was overwhelming. A dream that led to relics led to pilgrims, and pilgrims led to money, and everyone knew it. So they built a test. And the test they built is, I think, quietly brilliant. The dream itself was never evidence. What mattered was verification by discovery. The dreamer had to produce from the dream a fact that he could not otherwise have known, and that fact then had to be checked against the physical world in the presence of witnesses who had not heard the dream in advance. If a man said a saint had shown him a burial beneath the third pillar, they went and dug beneath the third pillar. If there was nothing, the dream was false. If there was something, the question became whether he could have known by ordinary means. Had he been present at the burial? Had he heard the story? Was there anyone alive who could have told him? Only when ordinary explanation was exhausted did the claim stand. Strip away the theology, and you are looking at the modern doctrine of guilty knowledge, the principle that the most powerful evidence a person can offer is a detail that only the true participant could possess. Every murder investigation in the world runs on this. It's why detectives withhold facts from the press. A confession that contains a fact never made public is worth 100 confessions that don't. They developed it to sort real visions from profitable lies. It works just as well on suspects. And the failures are instructive too, because the test had a hole in it, and the hole was collusion. If the man who dreamed and the man who dug were the same faction, verification meant nothing, and there was a great deal of relic fraud in the Middle Ages that ran on exactly that mechanism. The Church knew. That is precisely why the machinery of formal canonization and relic authentication tightened over the centuries, until eventually no shrine could be established, no miracle proclaimed, without an examination by an authority with no financial stake in the answer. Independent verification by a party without an interest in the outcome. That is the whole rule. It took them 400 years of fake saints' bones to arrive at it, and we still break it constantly. Let me end this stretch with the smallest of these cases, which is my favourite. In a village court in the 14th century there was a dispute about a cow. The cow had wandered, had been taken in by a neighbour, and both men now claimed her. There were no marks, no brands, no documents, 2 honest-seeming men, 1 animal, and no way to choose. The court's solution was not to weigh the testimony, it was to release the cow. She was let go in the space between the 2 men's holdings, and both men were required to stand back and stay silent, and the court watched to see which way she walked. She walked home. Animals do. And the court gave her to the man toward whose buyer she had gone, and recorded the reasoning, that the beast knows her own manger, and her knowledge is older than either man's word. There is no theology in that. There is no ordeal, no combat, no appeal to heaven. There is just a judge with an impossible problem, looking around the room for the one participant with no reason to lie. Rest now. Next, the laws written after a single feast went wrong, and the strange medieval doctrine that a man could be legally guilty of a death he caused 3 years earlier by accident. We're nearly at the end, and what's left is about time. Specifically, about the medieval law's strange and unresolved relationship with the gap between an action and its consequence. But first, the feast, because I promised you a feast that went wrong. The setting is a hall in the German lands in the 15th century, and the occasion is a wedding. Not a royal one, a prosperous one, a guild family marrying into a landholding family, the kind of union that took 2 years to negotiate and produced a document longer than the marriage contract of some princes. The feast ran for 3 days. That was standard. Guests came from a considerable distance, and hospitality of this kind was a public demonstration of status, which meant the quantities involved were enormous and the drinking was continuous. On the second night, 2 men who had come from different towns fell into an argument. The chronicle does not say about what, and the chronicle is almost certainly right not to bother, because in every account of every hall fight in every century, the subject of the argument is irrelevant. What matters is that one of them said something, and the other stood up, and there were knives on the table because everybody ate with a knife. And within 30 seconds 1 man was on the floor bleeding and the hall was in chaos. He did not die that night. He was carried out, bound up, and he recovered enough to travel home a fortnight later. And that is where the case became interesting, because he died 11 months afterward of a wound that had never properly closed. So, was it murder? The man who struck the blow had every reason to argue that it was not. His victim had walked out of that hall. He had lived for the better part of a year. He had been treated by a barber surgeon of dubious competence, had returned to work, had by some accounts drunk heavily throughout. A dozen things could have killed him. And on the other side stood the dead man's family, who pointed out the obvious. He was healthy on the second night of that wedding, and he was dead now. And there is a straight line between those 2 facts, and the line runs through one particular knife. This is causation, and it is one of the genuinely hard problems in law, and the Middle Ages did something about it that we have inherited almost unchanged. They drew a line in time. The rule that emerged, it appears in English law and in variants across the continent, was the year and a day rule. If the victim died within a year and a day of the injury, the law would treat the injury as the cause of death and the case was homicide. If the victim survived beyond a year and a day, the law would not, and the offence remained the assault. Now this is an arbitrary number. There is nothing magical about 366 days. A wound that kills at 11 months is not meaningfully different from one that kills at 13, and everybody involved knew that perfectly well. But that is precisely why the rule is intelligent, and I want to make the case for it, because arbitrary rules get a bad press. They had no pathology. None, there was no autopsy in any sense we would recognise, no way to establish whether the infection that killed a man had come from the knife or from the water. Beyond a certain interval, any inquiry into medical causation was pure speculation dressed as fact, and speculation in a capital case kills innocent people. So rather than pretend to knowledge they did not have, they picked a line. And the line did 2 things. It gave certainty. A man who had injured someone knew, after a year and a day, exactly where he stood, and could not be pursued for the rest of his life by a family waiting for the victim to weaken. And it protected against the worst error, because a rule that only catches the clear cases will let some guilty men escape, but a rule that catches everything will hang men for deaths they did not cause. That is a trade-off, made consciously by people who understood exactly what they were trading. And here is the part that ought to stop you. That rule survived into the modern era. It was still law in England in the 20th century. It was abolished there only in 1996, abolished because medicine had finally advanced to the point where it was doing real harm, keeping people alive on ventilators for years after an injury that would once have killed them in a week, and letting the person who caused it walk away untouchable. Some American states abolished it even later. A few versions of it linger still. A rule invented because nobody could tell what a wound would do, surviving 500 years and dying only when the machines caught up. Now let me give you the other side of that coin, which is the medieval law of accident, and which is much less comfortable. There is a concept in Old English law called the deodand. The word is Latin, and it means roughly given to God. Here is how it worked. If an object caused a person's death, a cart that ran a man over, a horse that threw and killed its rider, a millstone that came loose, a beam that fell, a barrel that rolled off a wagon, that object was forfeit to the crown. Its value was assessed, and it was surrendered, and the money was supposed to be applied to pious uses, masses for the dead man's soul, alms, the upkeep of a church. The object was guilty, not the owner, the thing itself. You can hear the echo of the Uglitch bell in that, and it is the same instinct. The world is a moral household in which things as well as people have places, and a thing that steps out of its place must be dealt with. A cart that kills has become, in some way that the medieval mind found perfectly natural, unclean. But watch what the deodand actually did in practice, because the practical effect drifted a long way from the theology. The owner of the object lost money. That is the operative fact. Every time. It did not matter whether he had been careless. It did not matter whether he had been anywhere near. If your cart killed someone, you paid the value of the cart, which means the deodand functioned, in the real world, as a system of strict liability for dangerous property, funded by a levy on the owner. And it meant that every man who owned a heavy wagon, a large horse, an unfenced mill pond, had a continuous and entirely financial incentive to keep it from killing anyone. And it lasted, this strange thing, until something happened that it could not survive: the railways. In the 1830s and 1840s, the deodand met the locomotive, and the courts of England found themselves confronting the following logic. A train has crashed. People have died. The object that caused the death is the train. Therefore, the train is forfeit. Juries, and this is the wonderful part, began doing exactly that. Coroners' juries, made up of ordinary people who had just seen the bodies pulled out of a wreck, started returning deodands against locomotives and rolling stock, assessed at enormous sums, because the ancient law said the instrument of death was forfeit, and here was the instrument of death sitting on its side in a field. The railway companies were horrified. They were also extremely well represented in Parliament. In 1846 the deodand was abolished, and in the same year, the very same year, Parliament passed what became known as Lord Campbell's Act, which for the first time gave the family of a person killed by another's negligence the right to sue for their loss. Look at what happened there. An ancient rule that made an object magically guilty was killed because ordinary people had started using it as a weapon against industrial negligence. And in the same breath, it was replaced by a modern rule that made the company legally liable instead. The magic was stripped out and the money was left in place, and what remained was wrongful death law, which is why every family who has lost someone to a corporation's carelessness has a claim today. The deodand did not disappear. It grew up. One last thing, and then I'll let you go for the night. I have been telling you all evening that these laws were reasoning built on faulty premises, and I stand by that. But there is a version of that observation that flatters us too much, and I want to close by taking it away. Every legal system on earth today is also reasoning built on premises. Ours are different premises. We believe things about causation, about responsibility, about what a person is, that would have seemed as odd to a Basel magistrate as his beliefs seem to us. And some number of our premises are wrong. We do not know which ones. That is what it means for a premise to be a premise. 800 years from now, someone will sit in the dark and describe our courts, and they will say, they were not stupid. They had a model of the world. Given the model, the reasoning was sound. And then they will name the thing we got wrong, and it will be something so obvious that their audience will laugh. The people in these stories were not fools. They were us, working with worse information and doing the same thing we do, trying to build a set of rules that would let a few thousand frightened people live near each other without tearing each other apart. Mostly, it worked. That is the astonishing part. There's one stretch left, and in it I want to bring all of this together. The pigs, the bell, the corpse, the rooster, the widow on the scaffold, the cow who walked home, and show you exactly how much of tonight is still sitting in the law that governs your life right now. Rest, there's nothing left to be afraid of. One last stretch. If you're still awake, you've done better than most. And if you're not, if this is playing quietly into an empty room, then this part is for whoever finds it in the morning, halfway through, with no idea how they got here. Let me bring it all together. We started with Rats, a young lawyer in Autun who was handed a joke and refused to treat it as one, and who argued that his clients could not be condemned for failing to appear when they had never been properly summoned and could not safely travel. And the court agreed. Everything else tonight follows from that moment, because that is the moment the medieval mind shows you what it actually was. Not credulous, not lazy, obsessive, absolutely determined that the forms be observed, that both sides be heard, that a defendant, any defendant, even one with a tail, be given the protections that the law promised. We are the inheritors of that obsession, and we would not survive a week without it. So let me do the accounting. Let me tell you exactly what you are carrying from tonight, right now, in the laws that govern the country you are lying in. From the piglets of Savigny, acquitted in 1457 because they were too young to understand, the principle that criminal guilt requires capacity. Every jurisdiction on earth has an age of responsibility. Every one of them has a defence for those who cannot comprehend the nature of the act. We argue about where the line sits, we argue bitterly, but nobody argues about whether there should be a line. A court in Burgundy drew it over 6 animals nobody thought to name. From Basel and the burned rooster, the requirement that a serious accusation pass a threshold before the machinery starts moving, a magistrate's finding, a grand jury, a prosecutor's charging decision, the filter that stands between your neighbour's grudge and your front door. From the locusts and the field set aside for them, the idea that a party with no voice can have interests articulated on its behalf, and that a resolution can be a settlement rather than an extermination. Every environmental easement in the world is that judgment wearing modern clothes. From the bell of Uglitch, flogged and tongueless and dragged to Siberia, the criminalisation of the false alarm. The recognition that the power to summon a crowd is a power the state must regulate, because a crowd summoned on a lie kills people. From the cadaver synod and the terrified deacon standing beside a corpse, the rule that the dead cannot be tried. And far more importantly, the doctrine that a sacrament, or by extension an official act, is valid regardless of what is later discovered about the person who performed it. Your marriage does not dissolve if the registrar turns out to be a criminal. Your deed does not evaporate if the notary is struck off. The office holds even when the man fails, and that principle was hammered out, because Italy spent a decade genuinely uncertain whether it had ever been baptized. From Carouge and Legris, and a woman sitting all day beside a pyre, the beginning of the end of trial by combat, and the slow realization that the outcome of a fight tells you who is stronger and nothing else at all. From Jarnac, and a king who watched his friend die over a rumour and swore an oath in front of his whole court, the formal end of it in France. From Abraham Thornton in 1818, whose lawyer read the statute carefully and discovered that it still said what it said, the reminder that laws do not die when we stop believing in them. They die when we repeal them. Everything else is just neglect, and neglect leaves the thing loaded. From the Dog of Montargis, who probably never existed, the reminder that stories shape law whether or not they happened, and that a tale repeated for 4 centuries becomes a kind of evidence in itself. From the old men on the riverbank and the children bumped against boundary stones, the entire law of hearsay. Every rule about what a court may hear second-hand, and under what conditions and why. It began as an attempt to manage the memories of the dead. From the appeal of felony, brought by widows in their husbands' names, the notion that a wrong done to a person does not vanish with the person. Victim impact. Survivor standing. The dead retain a shadow in the courtroom. From the hue and cry that the duty to pursue and the accountability for the pursuit must be issued together, never separately. From the dream trials and the digging beneath the third pillar, guilty knowledge. The single most powerful thing an investigator has. Withhold a detail and see who produces it. From the cow, released between 2 claimants and allowed to walk home, the instinct to look. When all the humans in the room have a reason to lie, for the one participant who does not. From the wedding hall knife and the man who died 11 months later, the year and a day rule, and behind it the deeper acknowledgement that where knowledge runs out, a clear arbitrary line is more just than a confident guess. That rule outlived the Middle Ages by 5 centuries and died only when medicine finally made it cruel. From the deodand, the guilty cart, the forfeit millstone, the locomotive assessed by a coroner's jury standing over a railway, cutting full of bodies, wrongful death. The right of a family to be compensated when an organisation's carelessness kills someone they love. It came from the belief that an object could be morally stained, and it survived the death of that belief because the money it moved was doing something the law still needed done. And from the bear in the market square, strict liability. Keep something dangerous and you answer for it, and the strength of your fence is not a defence. That is a great deal of modern law to have come out of a night of ridiculous stories. And I want to be careful here, because I have been drawing straight lines all evening for the sake of a good narrative, and real legal history is never that clean. These ideas had many parents. They emerged in several places at once. Some of the connections I have drawn are direct and documented, and others are family resemblance rather than descent. But the pattern is real, and it is the thing worth taking with you. The pattern is this. Law is not designed. Law accretes. Nobody sat down in a quiet room and drafted the legal system you live under from first principles. It was assembled, piece by piece, over roughly 1,000 years, and almost every piece was added in a hurry, by frightened people, immediately after something went badly wrong. Every rule is a scar. Somewhere behind each one there is an incident, a specific afternoon, a specific room, a specific person who did a specific thing that nobody had thought to forbid because nobody had imagined it was possible. And that means something rather comforting, I think, at this hour. It means that the strangeness of these old laws is not evidence that the past was mad. It is evidence that the past was paying attention. Each absurd statute is a memorial to a moment when a community looked at a disaster and said, "Not again." They were often wrong about the mechanism. They were sometimes cruel. But the impulse to notice harm, to name it, to write it down so the next generation would not have to learn it the same way. That impulse is the entire foundation of civilization, and it is unbroken from Autun to whatever ordinance your city council passed last month. And here is the last thought, and then I'll leave you. Every one of the people in tonight's stories is completely gone. The lawyer who argued about the cats, the judges who spared the piglets, the bishops who sat in that basilica and said nothing, the woman in black on the scaffold who was right and who spent a whole December day waiting to find out whether being right would be enough, the old man who remembered the hedge because someone had held him upside down over a stone when he was 7 years old. They are gone, and their world is gone, and most of them do not even have names in the record. But the rules they made are still working. Right now, tonight, while you sleep, somewhere a court is applying a principle that one of those people invented under pressure, in a bad situation, without knowing they were inventing anything. Their reasoning outlived them by 500 millennium. They will never know. That is the most that any of us gets, really. Not to be remembered, almost nobody is remembered. But to have added one small correct thing to the enormous inherited structure that keeps strangers from tearing each other apart. To have noticed a problem and fixed it, and had the fix survive. The pigs went home. The rats were never served. The bell came back from Siberia after 300 years, tongueless, and hangs there still where anyone can go and look at it. And the law goes on, patched and scarred and full of strange old rules that nobody can quite explain. Every one of them a message from someone who is not here anymore, saying, "This happened once, and we did not like it, and we would prefer that it did not happen to you." Sleep well, history lovers. If you made it to the end awake, or if you're hearing this now on a second pass, in daylight, wondering what you missed, leave a comment and tell me which of tonight's trials was the strangest to you. I read them all. And tell me where you're listening from and what time it is where you are, because that's genuinely one of my favourite parts of doing this. If this helped you drift off, a like helps more people find it, and subscribing means the next long night finds you on its own. There's more where this came from. More trials, more absurd statutes, more people in the past being deeply serious about deeply ridiculous things. Until then, rest easy. Nobody is putting you on trial tonight. Peace.